open the consideration of the appointment of Lori A. Bolton Fleming for Judge of the Kansas Court of Appeals. And before we get started, I want to share a little bit about the procedure for those following along in the committee meeting room and those watching online. That the business before the committee today is the consideration of the appointment by Governor Kelly, like I said, of Lori Bolton Fleming as a judge of the Kansas Court of Appeals to serve subject to retention elections as set forth in statute, succeeding the Honorable Henry Green, Jr. KSA 20-3020 provides that any vacancy on the Court of Appeals is filled by appointment by the governor with the consent of the Senate. The clerk of the Supreme Court is required to give notice to the governor of any vacancy, and the governor accepts applications for the appointment and submits an appointee to the Senate for confirmation. And that's what we hear about today. To be qualified for appointment, the person shall have been regularly admitted to practice law in the state of Kansas and engaged in the active and continuous practice of law as a lawyer, judge of a court of record, or any court in this state, full-time teacher of law in an accredited law school, or any combination thereof for a period of at least 10 years prior to the date of appointment. Since KSA 20-3020 became effective in 2013, the appointment and consent procedure has been used 11 times. And the Senate Committee on Judiciary, in the years that I have presided over this committee, this will be our 7th such confirmation consideration of appointees. So recognizing the importance of precedent in such historic matters, the committee will conduct this hearing in the same manner as we have conducted the 6 prior hearings. So with that then, I would like to first invite Ms. Fleming to make any opening statement or remarks she may have prepared for today. Please introduce yourself and welcome to committee. Let's make sure your microphone is on as well so we can hear the remarks. Thank you.
Let's try it again. Good morning. Madam Chair, Vice Chair, Ranking Member, and members of the committee, my name is Lori Bolton Fleming, and I am grateful to appear today in support of my confirmation to the Kansas Court of Appeals. I appreciate the time you have spent considering my nomination, and I am excited to share a little bit about myself and answer any questions you may have. I am a lifelong Kansas resident. I was born and raised in Fort Scott in southeastern Kansas. I graduated from Pittsburgh State University, and I spent a short time teaching music in Leavenworth Public School System, and then teaching English and coaching debate and forensics at Fort Scott High School. I was inspired to attend law school by a few of my 7th-hour English students who happened to live at a local boys' home. As I got to know them and heard their stories, it occurred to me that their stories might have a different ending with someone in their corner. I enrolled in Washburn Law School with the goal of being an attorney who helps kids. At Washburn Law School, I served as editor-in-chief of the Washburn Law Journal and as a teaching assistant for legal research and writing classes. I graduated near the top of my class, and I was named Outstanding Senior Woman. One of my law school experiences was to work as a judicial clerk in Shawnee County. My work as a judicial clerk planted a seed for me that would grow for many years, my desire to someday be a judge. I knew I had many years of hard work ahead of me as an attorney to be the best possible judicial candidate. And so, following graduation, I returned to Southeast Kansas, first to work as a prosecutor, one who specialized in cases involving kids. Over the next 11 years, I would work in a variety of areas of law, with a goal of developing a well-rounded legal background with significant experience in many areas. I would work as a prosecutor, criminal defense attorney, civil plaintiffs, and civil defense attorney, and I would practice in many other areas, such as domestic, adoption, business, and probate. During this time, I gained valuable experience practicing in both state and federal courts, including district and appellate practice. In addition to my law practice, I served as an adjunct professor at Pittsburgh State University, and I served as an attorney for the Student Legal Aid Clinic, also at Pittsburgh State. In 2012, I was selected by Governor Sam Brownback as a district judge for the 11th Judicial District of Kansas. Over the last 13 years, I have had an opportunity to handle cases in nearly every area. As an example, I have handled multiple high-level felony jury trials, complex civil jury trials, and bench trials in a wide variety of areas. I believe that I have significant, well-rounded experience as a district judge, and that litigants, attorneys, judges, and our community consider me to be a hardworking, fair, and impartial judge who treats everyone with respect. In 2021, the Kansas Supreme Court named me Chief Judge of the 11th Judicial District. Our district includes Cherokee, Crawford, and Labette counties in the southeastern corner of the state, and I am responsible for the operations of 5 courthouses in those 3 counties. As Chief Judge, my responsibilities include court budgets, case assignments for our judges, supervision of our employees, and implementing our strategic plan. I am proud to share with you that over the last few years, we have experienced success in our judicial district by creating programs such as our new Recovery Court, which opened in 2024, and a Grow Your Own Attorney program that provides support for students interested in the law from elementary school through law school. I am proud of the hard work of our employees and our community stakeholders in achieving these and other goals. During this time, I have also been asked to serve as an assigned district judge twice on the Court of Appeals and once on the Supreme Court, in 36 cases for the Court of Appeals and in 2 cases for the Kansas Supreme Court. I learned greatly from these experiences and feel that my familiarity with the appellate process would allow me to hit the ground running. I have also been asked on many occasions to serve as a leader in our judicial branch. In addition to my experiences as Chief Judge, I have been asked to serve on many committees and task forces created to address significant issues facing the judicial branch, such as the Rural Justice Initiative, the Cybersecurity Committee, the Digital Evidence Committee, the COVID-19 Task Force, and the Pretrial Justice Task Force, as well as many others. As to my personal life, I have been married to my husband, Kyle, who joins us today, since 2002. He owns the Fleming Law Firm in Pittsburgh, Kansas, and we met at Washburn Law School. We have 3 beautiful children, our son Aiden, who is a junior at the University of Notre Dame, our son Keegan, who is a sophomore at the University of Kansas, and our daughter Miriam, who is a senior at St. Mary's Colgan and who will attend K-State in the fall. They regret they cannot be here today due to their studies, but I'm sure they are joining us online. I have applied for the Kansas Court of Appeals because I believe we need qualified, well-rounded judges to serve on our appellate courts, that we need people with judicial leadership experience who are willing to continue to lead the projects and initiatives within the judicial branch, and that our appellate courts are well-rounded and best served by having people serve from all parts of the state. As a judge, I have taken an oath to be fair and impartial in my decisions, to honor the state and federal constitutions, and to respect the boundaries of our 3-branch system of government. This is an oath I have maintained as a judge for the last 13 years, and it would be my honor to continue to do so on the Kansas Court of Appeals. Thank you, and I am happy to answer your questions.
Thank you, appreciate that. Committee, so we're going to allow each member of our committee to have an opportunity to ask the appointee questions. So we're going to do that. Usually we do that in alphabetical order. So we're going to go ahead and continue with that, and we will have time to circle back if we have an opportunity to. We'd like to conclude our business today at 9:30, but we'll see how it goes. We have to be on the floor at 10 a.m. this morning. So want to first then invite Senator Argabright any questions he may have for the appointee.
Thank you, Madam Chair. Good morning, Lori, and congratulations. It's quite a process just to get here, so congratulations to that. I noticed that you are an elementary music teacher, and although I will skip over this, growing up in the 80s, I was going to ask a question on that, but that's probably not the good way to lead off here. So thank you for working with children over the years. When you have a topic, an issue as a presiding judge, can you tell me what your 2 to 3 priorities are when you dive into your research and your case studies? What's your process and priorities?
Thank you, Senator. I think that's a great question to start with. So let me just kind of talk generally about how I make decisions as a district court judge. So I issue written opinions the vast majority of the time, unless it is a very, very simple issue where I, quote, rule from the bench. I feel that I owe the people that are in my courtroom a very thorough explanation of my ruling. And so I take a case what's called under advisement. It immediately goes on my calendar. I usually only allow myself a week or two to get that done. And then I dive into the legal research. So I start by looking at any briefs that have been filed by the parties, and I identify the issues in the case. And then I dig into the legal research. I also have to determine what the facts are in the case. So normally in a bench trial, as a judge, I am the finder of fact. If it would be a jury trial, of course, it would be a jury. So once I've determined what the facts are in the case, I've made a factual determination, and I've decided what the law is that applies in the case, then I just simply apply the law to that set of facts, and I reach a conclusion. I am very careful about my opinions. It's very typical for me to write an opinion, set it aside for a day, come back to it, review it. I'll do that 3 times before I will actually issue the opinion, because I'm just very aware that behind that case caption, there are real people, and this affects their life. So I want to get it right. So I hope that answers your question, Senator.
Thank you, Madam Chair.
Sure, other questions?
Yeah, so we have a shortage of attorneys in our great state. How will you promote that profession to our young people as a presiding judge?
Thank you, Senator. That's one of my favorite questions as a former educator. So I serve on the Rural Justice Initiative, and that group has examined the attorney shortage in the state. They have proposed a number of solutions. Some of those solutions are at the state level, some are at the regional level, and some are at the local level. And so as the Chief Judge, my focus has been what can we do here in our local community to grow more attorneys. So to that end, we've done a number of things. First, we have partnered with Pittsburgh State University, our local bar association, our public school districts to create a number of programs. So actually next week on April 2nd, I'm hosting Law Day. And so we've invited area high school seniors, university students, law students. I think we have representatives from 5 law schools. We have law firms with the hope of just letting students know this is what's available to you and how can we help you. I also do a lot with our local schools, mock trials, things like that. So we're working hard as an entire community to grow our own attorneys.
Thank you. Thank you, Madam Chair.
Thank you. Next, we will give the opportunity to Senator Bowers for any questions.
Thank you, Madam Chair. Us two at the beginning of the alphabet, we're kind of used to that. So my colleague stole my question. We do serve on the Rural Justice Initiative, and we did good work that 2 years, I believe. And remember, one thing we learned is our Chamber of Commerce's, our local entities don't do a good enough job welcoming and introducing our new lawyers to the community. So can you speak a little bit to that on the grassroots effort that you're working on, other than just in the students in the high schools?
Yes, thank you, Senator Bowers, and it was a pleasure serving with you, getting to know you on that committee. So one thing you have to keep in mind is that our shortage is not unique to our profession. It's actually occurring in a number of different professions, and so rather than work in a vacuum, what we've tried to do is identify other professions in Southeast Kansas that are in the same situation. And so to that end, there is a young professionals group that supports all the professions. We actually, as a bar association and court system, have created kind of a welcome to our Southeast Kansas community process, that if someone is interviewing in our area, whoever they're interviewing with knows they are welcome to come by the courthouse to meet the judges, to meet the attorneys. They often have a bar association dinner or happy hour to welcome someone. Because what we're finding is that people just have a lot of questions about living in a rural community if they've never done it. So just meeting people that live there and have raised their families there has been very helpful.
And your husband's a rural lawyer, so he certainly understands that as well. I really did like your words, qualified and well-rounded. I think you're exactly that, and a perfect person for this job. And then just in one thing I noticed in your resume, you wrote a paper, Criminal Procedure, More Than You See on TV. And I am actually anxious to read that someday. I think that'll give us a new perspective on how it really is in Kansas, in rural Kansas, and from eyes of a lawyer and a judge. So thank you very much, Lori.
Thank you, Senator.
Thank you. Now an opportunity for Senator Bowser to ask any questions.
Thank you, Madam Chair, and thank you, Judge Fleming, for being here today. I've had a chance to review your packet and visit with you personally, and it gives me a great deal of reassurance to know that we have such qualified judges as yourself. I'm certainly leaning towards confirmation. But if one of my colleagues asked me, one of my Senate colleagues on the Senate floor asked me about you, and someone who hasn't had a chance to view your packet or talk with you, and they asked me, why should we vote for you? Why should we confirm you? What would you tell them? What should I say to them?
Thank you, Senator. I think really the answer is just simply in my experience. I have a lot of significant judicial experience, and I think I'm a unique applicant in that I have it at multiple levels. So I've been a district court judge for 13 years. I've been a chief judge since 2021, and then I've been invited 3 different times to serve on the appellate court. So I've actually done the work that I would be doing as a Court of Appeals judge, and I've actually done it while also working full-time as a district judge. So one of the times that I handled a Court of Appeals docket, I was actually also handling a high-level felony jury trial, and so I would handle the trial during the day, and then I would write at night. And I think it speaks to my work ethic as well.
Thank you. Next, we will have an opportunity for Senator Clays to ask any questions.
Thank you, Madam Chair, and thank you, Lori. And we spoke, or I spoke actually more than anything, but and I enjoyed our time together. But I'm going to touch on one of the things that we talked about a little bit. There are some great legal minds on this committee, and I'm not one of them. But I will, however, attempt to weigh in on a topic that has concerned me for a good portion of my life, and that's judicial review. As many here know, it isn't explicitly part of our federal constitution, and it's not part of our state constitution either. Just as a reminder for those in the audience or others that may not remember, it was Marbury versus Madison that the Supreme Court claimed that power, and it was a dispute where they were really just looking for a compromise, and I think that played a big role into how people accepted it. But it's also interesting that that happened at the federal level, but then through some sort of transitive legal theory, the states have adopted it too, even though we don't have necessarily one that explicitly states that. And I know this is a near sacred principle for a lot of our lawyers here, so I don't want to step on their toes too much on this, but it's important to recognize that a lot of democratic countries don't have judicial review. Great Britain, who we got a lot of our ideas and our laws from, doesn't have judicial review. There is New Zealand also doesn't have it, and interestingly, the Netherlands not only doesn't have it, but they explicitly forbid it, which I found rather interesting. I guess my issue is that we've seen judicial decisions that have divided our country, probably the most famous or infamous being Roe v. Wade. Here we have judges finding a right to abortion where the plain text just doesn't exist. And what I find even most troubling about that is some of those self-same judges weren't able to manage to find a right to bear arms when we have plain text stating in the Second Amendment the right of the people to keep and bear arms shall not be infringed. So that's a really interesting paradox that they've managed to work their way through. But anyway, my problem with this is that it creates a real disconnect between the average citizen and the laws that, you know, in an ostensibly democratic republic aren't even being influenced by the voters. And I'm not here to attack judicial review. In fact, I think that if I were to be one of the framers, I probably would have some level of judicial review. But if it were baked in the cake, so to speak, I think that we probably would have looked at, you know, different ways that, you know, it wasn't such an opaque system like the amendment process in order to overcome one. You know, like we have legislators, we answer the voters every now and then. You know, and the same is true for most of our accountability system. So as it sounds now, we just have that Byzantine system to overturn the Supreme Court, or we can morbidly wait for justice to expire and appoint new ones, which doesn't seem very efficient. Anyway, to wrap this up, I'm not as clever as some of our lawyers here to make statements into questions, but my question is, just what are your views on the limits of judicial review?
Thank you. So as you and I discussed, Marbury versus Madison established the doctrine of judicial review in the United States, and it has, as you pointed out, been trickled down to the state courts. You know, I always come back to the idea of judicial philosophy to answer your question, and the idea of judicial restraint, which is my philosophy. I think as a Court of Appeals judge, I have an opportunity to always do a full analysis, even when an issue has been decided by a higher court. And so the way I decide cases now as a district court judge, and the way I would do it on the Court of Appeals, is a full analysis, and that includes an acknowledgement of controlling authority. So if there's a Supreme Court case that controls the issue, I am required to acknowledge that. It will control the outcome of the case. But I do my own analysis, and if I find there's a problem with the case law, with, you know, the interpretation, with the analysis, not only is it my right, but it is my obligation to point that out and to say something in my writing along the lines of, you know, I understand that this issue is controlled by the court's decision and, you know, State v. John Doe, but I would urge the court to take another look at this, and here is why. And then I would launch into my own reasoning. So I hope that answers your question, Senator.
Thank you. Next, an opportunity for Senator Corson for any questions.
Thank you, Madam Chair. I really appreciate you being here, appreciate your diverse experience. I think being a trial court judge is one of the best ways that somebody can prepare for being in the Court of Appeals. And in addition to that, you have actual experience with both the Court of Appeals and the Kansas Supreme Court. So appreciate having such a well-qualified nominee before us today. One of the things I'm really interested in is, you know, we have a great and really diverse state. And I didn't realize this until looking through your packet, that we have not had a attorney or judge from your judicial district on the Court of Appeals since 1978. And I just really think, not that you're going to rule differently, or not that any judge would rule differently. I mean, you really want to apply the facts to the law and reach a conclusion. But I do think it's important just for our citizens that we have geographic diversity on the Court of Appeals. And so I just wanted to kind of ask you kind of what you think that you would bring to the court as somebody who's from Southeast Kansas, from a more rural part of the state, why that might be important for us to have a diverse number of Court of Appeals judges from all around the great state, and not just Johnson County or Wichita or places like that. But what is the value in that? Because I think it's really important. Thank you.
I appreciate the question, Senator. So you are correct. There are not very many current justices and judges on the appellate courts that practice law in a rural area of the state before taking the appellate bench. So certainly there have been many that were born in the more rural areas, but then did not choose to practice in the rural areas. I had someone tell me that they thought it was something like 2 or 3 of the 21 judges and justices had actually practiced law or served as a judge in a rural area. The reason I think it's important to have geographic diversity is that as Senator Bowers and I traveled across the state talking to the more rural communities, one thing that really stood out is that our citizens want to feel represented in all three branches of government. And they don't always feel that way when they don't know people that are on our appellate courts. And so I think that that is important. I also think it's important to have rural voices on our appellate courts for leadership. So there are a number of initiatives that the court pursues, one of those being, as an example, recovery courts. So if you are in a more urban area, it is easier to start a recovery court. You simply have more resources at your disposal. The more rural courts don't have that. And so we're an example. We're a rural court. It has taken us 20 years to start a recovery court. We started that around 2001, and we're just now getting it over the finish line. And so when I talk to judges in rural areas, that's something they would like to have, but they don't know where to start. So I think having some rural voices on the appellate courts can also help with some of those access to justice issues.
Thank you. I appreciate that diverse experience, and I think I agree with you that having rural voices and a diverse geographic makeup of the court is really important for the court's work. So I appreciate that you'll bring that, and thank you very much.
Thank you.
Thank you. Next, an opportunity for Senator Haley to ask any questions.
Madam Chair, thank you, and thank you, Judge Bolton Fleming, for being here today. I too appreciate your making time in your schedule prior to this to sit down and to visit with us about where you'd be. I guess I should say, full disclosure, I think I've participated in all of the hearings. I've been on the Senate Judiciary, so since its inception. And full disclosure, having sat on those, I always affirm whomever the nominee is. Well, I guess there were two that I didn't because of their more political ties than their qualifications, but it's usually a slam dunk with David Haley, and delighted to see someone of your ability and your intellect and your commitment before us. Judge, I guess my question is, or that would be before you, and certainly succeeding, as I certainly hope you will, Judge Green, who has been on for quite some time, and I think gave a great level to his service to the court and to our state. And having you listed as certainly one of my mentors, as you and I visited, about Judge Karen Arnold-Berger, who has taken senior status as the chief judge on the Court of Appeals, but who will remain on the court, and who, in terms of temperament, intellect, in terms of, her dedication, I think, to understanding the history of who we are and how we are as a state, and applying some of that in many of her decisions, both as chief judge and now continuing on the court. I genuinely admire and consider her one of my mentors, and pleased to see that she's listed in your packet as a recommendation. So I guess that leads to my question, finally. You know, in these ever-shifting social mores, in Kansas and in our society as a whole, Judge, I wonder where or what your view might be on the role of stare decisis, or letting the decisions stand, fundamentally looking at the history of how and where we have been, and certainly taking under advisement the counsel that may have preceded some of these decisions. But where might you look to, or do you have any particular theory of stare decisis, of letting these decisions stand, that you'd like to share with us at this time, taking into account that one of your listed recommendations is my mentor on this decision, Judge Arnold-Berger?
Thank you, Senator. So if you're not familiar with the doctrine of stare decisis, so basically, if a higher court issues a decision on a particular issue in a court case, that must be followed by the lower courts. And I will say pretty rare. It is somewhat rare for that higher court to revisit that issue. And there has to be, it was clearly erroneous at the time it was decided, or there has been a change in the law. Usually the legislature has enacted a statute that makes the case not applicable any longer. And so as a district court judge, I am the trial court, and then, of course, Court of Appeals, and then Supreme Court. So as a district court judge, I'm bound to follow decisions from the Court of Appeals and the Supreme Court. On the Court of Appeals, I would be obligated to follow the rulings of the Supreme Court. So generally, that's how it works. But as I said earlier, I don't simply, in my opinion, say, you know, the outcome of this case is controlled by the Supreme Court decision and I'm done. I always do my own analysis, my own legal analysis, draw my own conclusions. With regard to, you know, what's going on in society, that's probably a good example of separation of powers. So policy decisions we leave to the legislature. We don't create law as judges. We simply apply the law that you create. And then finally, as far as Judge Karen Arnoldberger, as I know we discussed, she is my mentor. She's someone I think very highly of. She's very, very intelligent, but more than anything, her collegiality and her ability to bring people together and work on a project. So thank you for your question.
Well, thank you for your response, and also, again, for taking the time to be here. As I said at the outset, Madam Chair and Judge, I'm a slam dunk, unless, you know, I mean, there's anywhere, there have been those with half the credentials that I've affirmed, I've affirmed for that you present today. So welcome here, welcome to your husband and to your family in absentia that are here to the court, and I certainly will hope that you'll get a swift approval.
Thank you, Senator.
Thank you.
Thank you, and an opportunity for Senator Klemp with any questions.
Thank you, Madam Chair, and thank you, Judge Fleming. So I appreciate our conversation last week, and it went a long way, and just as we walked through kind of your philosophy in general. So, and I also appreciate the comments. I had most of the ones that we've talked about today written down, but not the one from Senator Haley. So I appreciate the question and your response to that. I think what gets lost sometimes is that you have a history in the first state of Kansas as a teacher, so I just wanted to acknowledge that and say thank you. So I'm a broken record when it comes to the first city in Kansas. And one of the questions I do have that haven't already been answered is and I'd be interested to get your perspective on it. Is if you have an opinion on a change or a series of changes that you feel would be helpful to make for our judicial system. And if you could add a little color there, that'd be great.
Thank you, Senator. So, you know, obviously in the last week, there's been a proposed change to judicial selection. As judges, we don't weigh in on that. The idea, again, is that government belongs to the people. The people, through their elected representatives, all of you, have decided to propose a method to the public, and they will vote, and that is a very democratic process. And so, you know, more generally, looking at our judicial system, I think something that will need to be addressed is probably the turnover of a lot of judges. We are so fortunate that the Kansas legislature chose to give a significant raise to judges so that we could attract quality applicants. It had actually reached a point that in some districts we had 0 applicants for those positions. And so we're starting to get some really qualified applicants. An unintended consequence of that is that some people maybe that were going to retire have held on a little longer to experience that benefit in their retirement. And so personally, I'm concerned that within a couple years, we may see waves of judges having to be replaced. And so I think it's important to have some experienced judges in leadership positions to provide that consistency.
Thank you for your time today, and thank you, Madam Chair.
Thank you.
Thank you. Senator Rose, any questions?
Thank you, Madam Chair. And thank you, Judge Fleming, for being here today. A few years ago, the legislature passed a new law. It was Senate Bill 180. It required any state agency or school district or local government that collected vital statistics for public health, crime, economics, or other topics to identify each individual as either a male or female at birth. You might be familiar with this. Attorney General Kobach sued the Department of Revenue and the Division of Motor Vehicles when it refused to change the policy for allowing transgender Kansans to change their gender markers on driver's licenses. And this wound up in the appellate court system. And Judge Arnold Berger asked the Solicitor General, and I'm wondering what your response to this would be, whether he had other cases showing that, so here's the question. If an attorney general concludes that a state agency is violating a law, does that mean the state is automatically suffering irreparable harm? Or, she asked, would this actually be a new law that if an agency is conducting itself in a way contrary to the interpretation of the law by the Attorney General, then a temporary injunction would be the appropriate way to get that stopped, rather than just a regular lawsuit that doesn't have injunctive relief? So, is the threat of injury to the state, does that take precedence over any harm the injunction would have on a group of individual Kansans? So just your thoughts on that.
Thank you, Senator. Well, so I guess the starting point again is that I'm not very familiar with what you're discussing. That wasn't an issue I followed. It hasn't come in my court. But I think I can answer this more generally. That again, it sounds like that was a process or a policy that the legislature authorized, and so as a court, we give deference to that. I have to be very careful to not give you an answer on a particular case because then I wouldn't be able to hear it in the future. But generally speaking, we defer to the work of the legislature. We only interfere in that, especially constitutionally. If there's a clear violation of the Constitution, if the public doesn't agree with the work they're done, then they have a remedy at the voting box. That's the remedy. So as judges, we don't make law, we don't modify law, we simply apply law, or we send it back to the legislature for further consideration.
Thank you, Madam Chair.
Thank you.
Thank you, and an opportunity for any questions from Senator Reichman.
Thank you very much, Madam Chair, and thank you very much for coming.
Thank you.
As I went through your application, I just started writing down all the things just qualified, and I quit. I was very, very well qualified, and I'm not going to take the time, because we're running out of time, of going through why I think you're qualified and you're a very good candidate. And I did like your answer from one of them that judges don't create law.
Mm-hmm.
I thought that was good. So I'm just going to throw a Hail Mary out there. I was listening to the news this weekend, and there was some concern about some of the federal judges on courts of appeal concerning of some of the things that the Trump administration was doing. And I was wondering if you'd want to weigh in on, which is not a very controversial thing, of what some of the federal courts of appeals are doing. And if you don't want to, that's fine. Thank you.
I'm happy to the best that I can. Well, I think what you're seeing play out at the federal level, right or wrong, whatever your position is a tug of war between constitutional powers. And separation of powers is really just playing out for the world to see. And, this maybe is oversimplifying things, but I always consider democracy to be a three-legged stool. That's how I've explained it to my students. And, if you kick out any one leg, then democracy falls. And so I think, what's happening is perilous. It's very concerning. I don't know how it's going to turn out, but that's what is playing out, is this tug of war. So I hope that answers your question.
Thank you, and an opportunity for any questions from Senator Schmidt. No questions. Okay, and then opportunity from Senator Shane.
Thank you, Madam Chair. Thank you, Judge, for being here today. Congratulations again on having made it to this point. So I'll avoid looking into the future and being prospective because I don't want to, maybe we'll magically touch on something that happens for you in the future. But looking back on your career, what would you say has been one of the most challenging or complex legal questions that you've seen in your career?
Thank you. That's such a great question. So I'd like to just talk maybe about a category of cases that I think are very difficult for a lot of different reasons. And those are cases, sex crime cases, where the victims are children, especially young children. Unfortunately, we have a lot of those. And so I'll just highlight on a few difficulties with those types of cases. So in the pretrial stage, something that happens a lot is that there's evidence that a defendant has perhaps participated in what we call prior bad acts, either on the same victim or other victims. And so we have litigation to decide whether those acts should be admitted into evidence. And we utilize a statute that the legislature created, KSA 6455, to determine whether they should be admitted for the purpose of plan, motive, opportunity, et cetera. Another issue that always comes up in those cases, and it's complicated, is it's typical for a defendant to have made a statement or giving a confession. And so we litigate whether that confession or statement should be admitted into evidence, and that's called a Franks v. Deno hearing. And the court is looking at the voluntariness of that statement under a totality of circumstances analysis. So that's just pretrial. At trial, actually, one of the most difficult issues is jury selection. I typically have to summons twice as many jurors as I would in any other case in those types of cases because, unfortunately, people have a lot of experience with that topic personally or their friends. I also have to remind the jury a lot that if you have something to share, please let's come up to the bench and share it privately because we don't want to taint the jury pool. So you really have to be careful with those cases for a lot of reasons.
Thank you, and an opportunity for Senator Titus.
Thank you, Madam Chair. Thank you, Judge Fleming. What would you say is the most important duty of a judge?
To be fair and impartial and decide cases applying the law.
I think you've gotten about this in a roundabout way with a lot of the questions, but could you just sort of share as you approach the law, what's your judicial philosophy? How do you view the Constitution and law, administrative regulations? How do you frame all of that together?
Thank you. Yeah, I think I've touched on it, but not fully explained that. So I think that's a great question. So when I talk about judicial philosophy, there's two parts to that answer. The first part is interpretation, and the second part is judicial decision making. So with regard to interpretation, we always, again, start with the idea that government belongs to the people. You have made the law based on the people. And so the vast majority of the time, when I look at the law the legislature has created, it's clear to me and I can just apply it. But in the instances where a word can be reasonably assigned more than one meaning, that means it is ambiguous, or a situation where maybe one statute within an act conflicts with another statute in the same act. So then I have to dig in, and I use what's called originalism, which means I go back in time to when that statute or act was created. I look at the legislative history, and I determine, what was the will of the people? What were they trying to do? And then I'm able to assign a meaning that way. As far as judicial decision making, again, I've touched on this, but I believe in judicial restraint, and so there's maybe 3 quick points to highlight there. Again, a respect for the separation of powers, and that we honor the United States and our state constitutions, that judges apply law, we do not create law, and then we acknowledge the binding authority, stare decisis, but as judges, we have a separate obligation to make our own rulings and point out where we don't agree.
One last question. I think it's great you have experience with the Court of Appeals. Through that, and as you've gone through this process, can you just talk about the difference of what you do at the district court level and what you'll do would potentially do at the Court of Appeals level?
Thank you. Yes, I think that's a great question. So maybe a few numbers to kind of illustrate the difference. So as a state, we hear around 400,000 court cases a year, and the vast majority of those are at the trial court or the district court level. So for me personally, over the last 13 years, I think I've heard around 7,000 cases. The Court of Appeals takes a portion of those cases where people have chosen to appeal up to the next level. And so there's about 2,000 cases that get filed in the Court of Appeals. A number of those get dismissed summarily for a number of reasons. So maybe the parties abandoned the appeal or it was a technicality. But the Court of Appeals will issue around 1,000 written opinions a year. And they are lengthy, well-reasoned opinions. And then in comparison, on average, the Supreme Court issues around 107, I think it is. So right now, I am in court all day, every day, hearing a very large volume of cases. That volume will go down. I do a lot of legal research and writing now, but then I will be solely focused on legal research and writing.
Thank you.
Thank you.
Thank you, Madam Chair.
Thank you, and thank you for the robust questions today from the committee and the answers. And congratulations on making it this far in the process and for being here today. I have a few questions. The first is regarding rules and regulations. And, Kansas law has somewhat rejected operative construction, and the U.S. Supreme Court has backed away from Chevron deference. However, we do have the Hansen versus Kansas Corporation of Commission decision here in Kansas from 2021, saying that an agency ruling within its area of expertise is entitled to some deference. So are there circumstances that would entitle an agency any level of deference in its legal interpretation under Kansas law?
Thank you, Senator. So I think my question is going to be, it depends what happens in this body, because I think you have a pending resolution maybe addressing this issue. As far as agency regulations, that's always a difficult area because sometimes there'll be a conflict with case law or there'll be a conflict with what the legislature has done. And so, should an agency have a greater power than an entire legislative body or a branch of government? So I'm going to be careful to talk about an individual situation so that I don't have to recuse. But generally speaking, again, if you look at separation of powers, that is a legislative function. Agency law, I'm not sure that it should necessarily receive deference.
Thank you. And there's been a couple of different interpretive approaches to our state constitution in some of the Hodes decisions, and you and I talked about that in our meeting in my office, and you kind of have the majority opinion, you have the dissent, and they show kind of two different interpretive models to analyze legislation under the Constitution. So in terms of your interpretive approach to analyzing legislation, what is your approach? Do you agree with the majority approach, which is kind of tiered scrutiny, or what's your approach?
Thank you. So let me be clear, I'm not going to offer an opinion on that case so that it doesn't make me recuse.
No, right, not asking
okay.
for on that
Yeah,
case, but what's your approach?
But I want to make sure I still answer your question. So, of course, there are three levels of constitutional analysis. We have strict scrutiny, heightened scrutiny, and rational basis. And what level you apply depends on the right at issue. And so in Kansas, what the Supreme Court has ruled is that if it is a fundamental right that appears in Section 1 of the Bill of Rights, it is going to be considered under a strict scrutiny analysis. So that is what happened in that particular case. I think probably the biggest difference in the analysis of all the justices is the way the history of the law was treated. I think that's where most people maybe debate whether, they agree or don't agree. Originalism was used by everyone, it appeared to me. They went back in time, tried to discern what the intent of the people was. Looked like maybe there was a disagreement on how that turned out. But so that's just kind of the constitutional structure of the decision.
Thank you. We've heard some questions today about the current administration in Washington, D.C., and talk about diversity and things. And there's been an executive order from the current administration regarding a declaration that there are two sexes. So I'm thinking Kansans might want to hear from you directly, and what your thought on is how you would answer the question, what is a woman?
Thank you. Well, again, courts don't make law, and so if the executive branch or the legislative branch has created a law or an administrative order that answers that question, it's not really before the court to answer that. We leave that to the people through the elected representatives. That certainly is not an issue that's come up in front of me.
And one of the questions from one of the senators here had to do with how Kansas has addressed the issue. I think it was Senate Bill 180 that was the question. So if you have anything further to add about that.
I don't. I'm sorry, I don't recall that specific piece of legislation, and it's just not something that has come up in our district courts in our area.
And tell us how you view the importance of judicial restraint. You've touched on it a bit, but when is it appropriate for appellate judges to make policy? Is it when reviewing common law? Is it when reviewing constitutional ambiguity? Or when would those circumstances arise?
We just simply do not create policy. We follow law. It is, again, left to the legislative body to create or address the policy or the feelings or the viewpoints, that you represent the people. They can communicate those views to you, and you can decide whether it's appropriate to codify those or not. But as courts, we simply do not make law.
Thank you. And then one final question. What, in your view, are the key differences? I mean, a lot of the current Kansas Court of Appeals, the justices, the judges on that court have come through this committee in recent years for confirmation, and we don't have that process for the Kansas Supreme Court. But I would ask, what in your view are the key differences between what we'll call the Kansas Supreme Court under Chief Justice Nuss and the Kansas Supreme Court under Chief Justice Lukert?
Thank you. Well, I've had the opportunity to work under both of those Chief Justices, and I don't know Chief Justice Nuss as well as Chief Justice Lukert. She was actually a district judge in Shawnee County when I was in law school, so that was when I first met her. I would say maybe one difference in style would be communication on the issues that are facing the judicial branch. I think that she has been very proactive in communicating with the legislature on what's going on. Probably an example of that, unfortunately, is our cybersecurity attack, where she appeared quite a bit to just discuss the needs of the judiciary. And she also has been our Chief Justice through COVID-19. So again, I think we saw more opportunities to lead through crisis. Unfortunately, that just happened during her term.
Thank you. Does the committee have any further questions? Senator Clays.
Thank you, Madam Chair. One of the other things we discussed, and this one's actually in my wheelhouse a little bit, is science. And I bring it up because, you're often given science, either opinions or research, and you're asked to digest that, probably with not a whole lot of background, and a lot of times you're going to have to trust. And I guess my concern is particularly recently, we see things on social media where people say, trust the science, which is such a bizarre statement to make about science, because the criticism is one of the basis of science. Proofs only exist in math and philosophy. The rest of us are stuck with evidence, just like we are in the judicial system, and that's the same thing in science. And Karl Popper, when he designed this, or participated in creating the scientific method, he came up with the idea that, all we can do is falsify things. We can't prove them true, we can only prove them false. And so, what science is trying to do is we build this edifice of a theory, and then we ask people to knock it down, right? I mean, so criticism is an essential part of science, and the fact that people are treating it like a religion. In fact, there's a term for that. It's called scientism, and people do that, are actually, believe that, it should always be trusted. I guess what concerns me most is, and again, getting back to my wheelhouse, which is social science, is that we don't have empirical methods, and I criticized the judiciary a little bit when we were together by saying that you don't allow us to randomly assign people to prison so we can do good science, and that's the issue, is we don't have that empirical evidence that you can maybe get in some of the other sciences, and what that's created is a replication crisis in psychology and some of the other social sciences. I'll try to wrap this up, but there's a statistician named Andrew Gelman. He's out of Columbia. He's just brilliant, and he has shown so many examples of just bad science, and I love one of his analogies, and I just want to share it with you. He said that social science is like trying to use a bathroom scale to weigh a feather, and the feather is resting loosely in the pouch of a kangaroo that's vigorously jumping up and down. And so, the measurement tools just aren't precise enough for what researchers claim. And so we get these research findings, and I shared this with you when we were talking. I actually looked up the actual person that did it. It was actually Dr. Ralph Welch, but he looked at juvenile delinquents and found that there was a high rate of corporal punishment in their background, and came up with the theory of the belt theory of juvenile delinquency. The problem with that is that the fundamental flaw was that it failed to compare corporal punishment in the general population. And at that time period, spanking was extremely common in American homes. So, without establishing proper controls, we have this whole theory out there that people are adopting and coming up with programs for and basing legislation off of, and it has no basis. So I guess my question is just to have you react to that and kind of get an idea of how you approach science and whether you have a healthy amount of skepticism when you're given science. And anyway, I'll leave that up to you to answer.
Thank you. And yes, I recall our conversation, and I appreciate it. So, kind of two different points on that. The first is, as far as the admission of scientific evidence in a court of law, of course, we have a legal standard for that, and it includes a lot of different things, and one of those is peer review and et cetera. I think what you're talking about is maybe more generally when the judiciary relies upon evidence to make decisions maybe in programming. For example, like we talked about recovery court. And, I just think it's important to hear your perspective and other perspectives when we're considering those programs. And I like that many times before the court will embark on a new journey or new program, they'll have a stakeholder group that includes the legislature for that exact reason, because we may not be thinking of those things. It may not even cross our radar. So I think it's helpful to have communication on those types of issues. So I appreciate that. Senator Warren, really briefly, on your question, I think I maybe misunderstood your question, and I want to make sure I touch on it. You were asking about creation of law, and I was thinking still along statutory. Of course, we have common law. Stare decisis just means that, the high court at some point has ruled on an issue, and we continue to hold that position. So there is a body of common law that courts do make. I was simply thinking along the lines of statutory.
Thank you, and I think you answered, the importance of judicial restraint in also making common law as well. So, thank you. Committee, any other questions? So thank you for that again, and we'll give you the opportunity if you care to make any closing comments to the committee.
Thank you. I have had the opportunity over the last few weeks to spend time with each of you, and thank you for squeezing me into your schedule. I have seen firsthand, I've sat through many of your Senate sessions, how busy you are and how hard it is to squeeze in people that want time with you. So thank you for giving me your time and attention. It's just been a joy to be a judge the last 13 years, and I'm excited to continue to do that and would love the opportunity to do it on the Court of Appeals.
Thank you. You can go ahead and have a seat. Appreciate your testimony today. It has been the practice of this committee in considering judicial appointees when we do that in a single day because we're close to the end of session, to take a recess before committee discussion and action to provide members with a final opportunity to review the materials and testimony you've heard presented today. So we're going to recess for just 5 minutes, and we'll reconvene at 9:40, at which time we will take up committee discussion and action on the appointee. Thank you, committee. We will now call the committee back to order and open it up for, is there any discussion or a motion from the committee regarding the appointment? And I will remind the committee that there are 3 possible motions. One is, I move the committee recommend the appointment favorably for confirmation by the Senate. One is, I move the committee recommend the appointment be not confirmed by the Senate. Or I move the committee report the appointment to the Senate without recommendation. And before a motion, is there any discussion? I would like to add a thank you to Judge Fleming for visiting. It sounds like with most of the committee to share your appointment and what you would bring to the bench. And I understand it's been an arduous process to have come this far, and wishing to serve our state in this capacity. So, and welcome, you had introduced your husband here as well and your family watching online. Given that and the testimony that we heard today and what the senators have in their packets, is there any further discussion? Open for discussion. Yes, Senator Argabright.
Thank you, Madam Chair. I move the committee recommend the appointment Lori Bolton Fleming favorable for confirmation by the Senate.
Thank you. And a second from Senator Bowers. Any further discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye.
Aye.
All opposed, no. The motion carries. Congratulations, Judge Fleming. You're advancing then to the full Senate. And good luck to your kids and their endeavors as well that you shared with us here today. So with that, committee, then we are done with our confirmation hearing and want to take just a few minutes to wrap up our work from the session with possible approval of minutes. You have the minutes in front of you. They are from the week of March 3rd, the week of March 10th, and March 17th and 18th. So March 3, 4, 5, 6, March 10, 11, 12, 13, and March 17 and 18. And we did go back and include in the minutes those who we understand wish to be recorded as noes on a couple of votes. So with that then, is there any discussion or a motion? Senator Haley.
Yes, Madam Chair, I did want to note that on Monday, March the 10th, I was not physically present, but it has me as being absent, but excused, but I was online. I don't know if that counts as presence being online or not, but if that's considered present or not.
Thank you, Senator. You wouldn't be present to vote on motions, but if there's a motion to amend those minutes that you were present on WebEx, we can do that. Is that your motion?
I just don't know whatever
Okay.
the
I don't
chair
recall how
or the committee's pleasure is. I just didn't know if there was
how we've done that in the past. Senator Reichman.
Thank you, Madam Chairman. How do we know that the senator was online? I didn't hear him say a word.
Madam Chair, that's a good point.
Good point.
I do think I tried to indicate on there, these are recorded. We do have I hope we have it, we do have, the meetings have been recorded. Do we maintain?
So through our IT services, we would have a record if a senator is present on WebEx, though no comment was made. Okay, and let us go back and confirm that. And then is it the will of the committee to, if we have confirmation from the transcript that Senator Haley was present on WebEx, that we amend our meeting minutes to duly reflect that, Senator Reichman?
I'll make that motion.
Okay, and is there a second? Senator Rose, all in favor signify by saying aye. Those opposed, no. The motion carries. Senator Haley.
I abstain from that vote, Madam Chair, just record
And could we
reflects.
have the minutes reflect that Senator Haley abstained from the vote on that motion? Thank you. Any other discussion or motion for the minutes? Senator Titus.
Madam Chair, I move we approve the minutes as amended.
Is there a second? Senator Argabright. You all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. Thank you, committee, for your robust work this session, and it has been a pleasure to work with you. Make sure that you do turn in your confirmation packets to the committee assistant, Barbara Moore, for shredding, and want to thank staff for their great work this session. Without you, we couldn't have been conducting our business. So with that then, thank you everyone, and the Senate Judiciary Committee is adjourned.